Which cryptocurrency is being attacked by the SEC after XRP? How long will crypto holders believe in Ripple? How much will XRP cost in mid-2020? 3. We will answer all. Ripple Labs has been fighting the U.S. Securities and Exchange Commission aggressively, and their most recent filing is no exception. In response to the SEC's letter of supplemental authority about the regulator's motion for summary judgment, Ripple Labs presents a confident and powerful rebuttal. The U.S. Securities and Exchange Commission, SEC, has cited an enforcement action against investment advice company Commonwealth Equity Services as evidence in its ongoing legal dispute with Ripple Labs. The legal team for Ripple, however, has replied quickly, stating that the reference decision has no bearing on their fair notice position. The SEC is suing Ripple Labs and two of its executives, Brad Garlinghouse and Chris Larson, alleging that they raised over $1.03 billion in an unregistered continuing digital asset security sale. Ripple's principal line of defense is that the SEC didn't give it enough time to prepare for the securities fraud action it plans to file in December 2020. The SEC submitted oral arguments to the presiding judge on April 11, stressing the Commonwealth judgment that a long-standing court precedent provides enough fair notice. The SEC stated that Ripple Labs had sufficient notice of what defines a security because of the precedent that led to the formulation of the Howey test. The SEC said that their case against Commonwealth provides more support for their decision to reject Ripple's reasonable notice position. On April 13, however, Ripple's legal team submitted a response in which they argued that the decision referenced by the Commonwealth did not offer further precedent for dismissing Ripple's fair notice position. The letter to the Honorable Analisa Torres, District Judge, outlined the key distinctions. Ripple argued that the Commonwealth case lacked contemporaneous evidence, while Ripple's situation involves abundant evidence, including communications from the SEC to third parties, showing that reasonable market participants did not consider Ripple's offers and sales of XRP as investment contracts. In addition, Ripple stressed in their answer that whether or not the Securities Act applies to their offers and sales of XRP is a threshold issue in their case. Since the court had previously rejected the SEC's reliance on such instances, the legal team contended that the SEC's reference to an unbroken chain of district court decisions rejecting fair notice defenses was irrelevant. The defense for Ripple argued that the most similar case, Upton, is a binding precedent and decided in favor of the defendant's fair notice claim, and that the court should do the same. Ripple and the SEC have been locked in a heated court fight for over 2 years over claims that the blockchain startup issued and sold XRP as an unregistered securities. The SEC has argued that the dominant blockchain firm broke the law when it sold XRP, and it has asked the court for a summary judgment in its favor. Yesterday, SEC Chair Gary Gensler testified before the House Financial Services Committee and was asked a number of questions about recent events in the Bitcoin market. The SEC was asked a number of crucial questions, one of the most pressing being whether or not he considers XRP to be a security. Congressman Warren Davidson posed a crucial question to the SEC chairman, asking whether he considers XRP to be a security. The chairman of the SEC declined to answer the question categorically. The head of the SEC has instead said that the question of whether or not XRP is a security is now being debated in court. We are in court, and if there are active discussion and litigation on that matter, Gensler added. When asked if Ethereum, ETH, is a security, Gensler again declined to say yes or no. Given that the head of the SEC has insisted that XRP is a security, his reaction caught many crypto fans off guard. Last year, Gensler shared this sentiment, stating that Bitcoin is the only cryptocurrency he believes to be outside the purview of the SEC. Many others thought Gensler was unqualified to lead the agency because of his tough stance on enforcement in the financial markets, notably the cryptocurrency industry. Interestingly, Representative Warren Davidson, R.O., felt similarly and submitted legislation calling for Gensler's ouster and a reorganization of the SEC. Chairman Gensler, Your record of failures to protect investors and abuses of power make it clear that we need to restructure the Securities and Exchange Commission, stated Davidson, Rep. Davidson filed legislation to remove Gensler as SEC chairman after he detailed some of Gensler's shortcomings and abuses in office. Davidson said, to correct a long series of abuses, I'm introducing legislation that removes the chairman of the Securities and Exchange Commission and replaces the role with an executive director that reports to the board where all authority would reside. Judge Annalisa Torres has not yet issued a ruling in the case of Ripple vs. the SEC. Ripple may benefit from the legislation intended to remove Gensler. Judge Torres will undoubtedly feel pushed to decide in favor of Ripple as a result of Congress casting light on Gensler's ineptitude and misconduct. One of Ripple's primary arguments against allegations that it marketed unregistered securities in connection with XRP has been the subject of a filing exchange between Ripple and the U.S. Securities and Exchange Commission. With the fair notice argument, Ripple intends to counter the SEC's motion for summary judgment in its favor. Ripple claims that the sale of XRP is not illegal because it did not have fair notice that doing so would be illegal, which is an affirmative defense under U.S. law. The fair notice defense may not be available to Ripple, however, because to recent legal judgments on the topic. In SEC vs. Commonwealth Equity Serves LC, decided earlier this month, the court also rejected a fair notice argument based on the identical facts as those presented by Ripple, and the SEC has now pointed the court in that direction. In particular, it decided that the defendant couldn't use the fair notice argument since the SEC's accusations were founded on a Supreme Court ruling from the 1960s. Even if the defendant claimed that the SEC had known about the harmful behavior for over 2 decades, this was still the case. In other words, the SEC's lack of prior enforcement of a regulation is not a reason for its violation at the current time. The SEC contended that the court should come to the same result since the SEC's argument is similarly founded on decades-old Supreme Court precedent, the Howey test for assessing whether an offering amounts to an investment contract and hence is a securities offering. In a brief, Ripple quickly responded, explaining that the Commonwealth case could not apply because the defendants there adduced no contemporaneous evidence supporting its defense that market participants lacked fair notice. Unlike its own case, Ripple claims there is abundant evidence showing that average people didn't consider the sale of XRP to be a security offering. Furthermore, the defense contended that the court should uphold the defendant's fair notice argument since it did so in Upton, the case upon which Commonwealth is founded. Even though Upton held that the defendants in that case could rely on a fair notice defense, a U.S. federal court has already ruled that Upton does not apply in Howey securities cases, so Ripple's response stands out. Although it is unclear whether or not XRP was launched via an ICO in the Ripple case, the fair notice finding against Elbry does not depend on this issue, and Ripple has taken the same stance as Lawbry, that it did not launch through an ICO. Although these precedents are not binding on the Ripple court, it is impossible to deny their persuasiveness. The fair notice argument is unlikely to rescue someone who fails the Howey standard,